Well, joining us now is the Minister for Crown-Indigenous Relations, Anandasangaree. Minister, thank you for joining us today.
Glad to be here, Michael.
Now, the courts says the law passed by your government does not exceed Ottawa's jurisdiction. But as you know, Quebec's argument here is that unilaterally your government amended the Constitution by giving Indigenous laws priority over provincial laws. Court reference aside, how do you answer those concerns being expressed by Quebec?
This is a very important day for Canada and for Quebec and for reconciliation. Today, the Supreme Court of Canada, the highest court in our land, reaffirmed the federal government's right and, in fact, obligation to bring forward Bill C-92. It essentially enables Indigenous peoples to draw down rights to care for their children. And it's a historical day. I believe that the paramountcy of Parliament and the need for us to implement C-92 was established clearly by the Supreme Court. I want to make sure that we work with the province of Quebec and all provinces and territories in order to ensure that Indigenous children are taken care by their people. It is long overdue. We know the harms of the child welfare system. I heard it yesterday at the Indigenous federal, provincial, territorial meeting we had on missing and murdered Indigenous women and girls, where the issues of the child welfare system was pronounced. And we know that the harms that this has caused over many, many years. And therefore, it's important that Canada move forward, and we encourage all provinces and territories to join in this journey.
And I hear what you're saying, Minister, but you know, from the Quebec perspective, if, for example, the court can uphold this jurisdiction of First Nations, Indigenous governments, vis-a-vis child welfare, what stops it from being expanded to another power, for example, health care?
There are a number of modern agreements that we have across Canada where some of these rights are already enshrined. For example, we have self-governing agreements in over 26 jurisdictions. We just had one with the Whitecap Dakota in Saskatchewan that was signed late last year. We just introduced legislation to recognize the Haida, Council of the Haida Nation as the government of the Haida people. So this is something that is part and parcel of our Constitution. Section 35 of the Constitution Act of 1982 establishes Aboriginal rights, and this is the next natural step in that process. And we look forward to working with the provinces and territories to implement not just legislation, not just C-92, but other very important legislation where there's self-determination over Indigenous people's rights within their communities. And that's the objective of our government, and that's the path of reconciliation that, frankly, we need to move on.
Okay, move on, as you say. We just actually spoke with Cindy Blackstock, of course you know her, of the Caring Society. She says, listen, she's happy with this reference, very happy, but she also says this is really just the first step. There is work that still needs to be done to make sure that Indigenous children are taken care of properly. Where does your government go from here? Beyond being happy with this ruling, what are you going to do with it as next steps?
First of all, there are dozens of tables right now where we are in the process of negotiating agreements that will enable communities to have the control over their children. And we want to accelerate that work. We have a number of communities already, over 7, the last count, who have signed agreements and who are in the process of implementing it. So I think the message for us today is for us to accelerate that work in tandem with Indigenous partners as well as the provinces and territories to implement the agreements that we are negotiating. Yes, this is frustrating, and I share the frustration with many who have waited for this ruling. As I travel across the country, Michael, I've heard from a number of communities who are ready and who want to enter into agreements, but who have paused or who are somewhat confused by the Quebec challenge. So I think this gives the clarity that is required for the critical discussions to conclude, as well as the structures to be put into place within and by communities so that children can be taken care of by their people in their own jurisdiction.
Mr. Anandasangaree, thank you for this. I really appreciate the time.
Thank you, Michael.